Hey, beautiful people. When any given task is performed successfully by others and it is accredited to you as a source of assistance for those other people to be successful at what they do, third parties will say, but that's a lie. Let him himself show what he has done. And you yourself now show what you have done, the evidence of it, and you share how you do it. Third party will nonetheless now say, well, let others show what he has done and how he has assisted them, whether you do or you don't. Those who have made their minds up to be hypocritical or to oppose you will never change. The truth is in the self-work, in the self-testimony, whereby whoever is speaking about something can show you that they themselves have first-hand knowledge and experience of it. That is shown here and on Patreon in many different ways that no one else will show you. And then you later realize the importance of asking them the question, well, what about you? When one thing is presented to you by the one you demanded of, you turn a blind eye. What about you? The majority of the people that tell you that just because someone else success accredited to you is insufficient, or that your own success that you show proof of. Now, this is even outside of any settlement check. This is with things like court cases, things we showed about express trust and using it with federal agencies that were shown on YouTube, things about how to use express trust to delineate that you're a natural person, asset protection and all that. And then the subtle evidence that we show and go through here on YouTube that no one else does. When you begin to question those people, you realize they themselves don't know. Because they don't know, they don't want others to know. And the mere act that the one that they're facing has self-evidence of using what they talk about to better their lives, and the fact that other people are using that same thing to better their lives, they just can't handle it unless they fall perfectly into this category called hypocrites. Hypocrites like that would also be the same one to tell you their courts are fraud. Their courts are fraud if you are incompetent. So here's another little helping hand for the hypocrites and those who are not satisfied with evidence being spoken of by the one they're criticizing, and others who affiliate themselves with those they criticize. Here's another helping hand for you. Whenever anyone gives you any given matter, whether you're wiping credit, or whether you're suing someone for tort, or whether you're dealing with any situation, student loan, mortgage, car loan, any form of discharge, you know the number one reason why most people fail or try to no avail? Because they don't comprehend the hierarchy of how evidence is admitted. So let's break it down a little bit further so that even the hypocrites can learn and grow in the process of criticizing others. The question here is, what are the increments of how evidence is qualified? This thing called federal rules of evidence uniformly exists on state level, so much so that each rule will have similar verbiage, and if under any circumstance one has some type of hesitation as to the validity of why and how it works. In the past, we've always spoke that the rules of evidence, or evidence itself, is a law of its own, and the operation of law, which are the rules and legality of it, governs the foundational law behind evidence. You want to go into equity? If you don't know the rules of evidence, you're still lying to yourself. And right in front of these things, on a state level or federal level, in this instance, the uniform version, which is the federal level, they show you the session of the Congress and the number of Congress that agreed to make this into a law of evidence. And they show you the medium to which it is printed and the print number. This by itself, ladies and gentlemen, is self-authenticating. Nonetheless, moving on. On the note of self-authentication and admission of evidence, there are four primary stages that any given evidence that you put into any circumstance, whether it be in a formal court or not, whether they tell you don't file motions, whatever you put in there, name it affidavit of affidavit, word for word, and they will classify it as a motion. Want to know why? Because motion just means to move. We went over this in the past. But if it's still not clear, the word motion simply means to move. The only thing that does not move, whether in the realm of mind, which is substance, or the realm of physical, which is form, the only thing that does not move in that realm is death. Even then, death still moves, because once the soul leaves the body still transforms and turns back to dust. So even in supposed death, motion still exists. You can look at that one tree stand still, but that thing is far more active than the whole population that wakes up every day, brushes their teeth, wash their butts, go to work, get taxed. That tree that is standing on one spot has more life activity than everyone else going back and forth around it. And these same foundational principles of nature law, which there's a maxim that says nature is thrice great, the same foundational principle is what is implemented into what you consider their rules. And one of those implementation of nature's law is motions. So don't worry, you don't put motions in. Keep arguing, keep fighting, rather than using competence to kick their ass. Keep playing the role of a victim. Keep looking for somebody to hand you a napkin to say, here, sorry about that. Rather than determining in your mind that you owe someone an ass whooping in a pen and paper based on your competency. You can't be competent if you're delusional and you're lying to yourself. But it's all right for those who are willing to listen to the truth, and most importantly, you put it to use. Here it is. If you seek a guru or you seek somebody to be your God, this is the wrong place. But if you seek self-sufficiency based on substance and how things work beyond speculation, things on black and white that we show here word for word, this is for you. If you value competency outside of just merely feeling good just to say something to get people riled up, this is for you. Different types of people that learn things of this nature. People who want to stay broke, angry, and incompetent. And those who don't want to stay broke, those who don't want to be angry, and those who don't want to be incompetent. Whatever category you fit in, as I always say, best of luck. Here's another jewel for you. The four main categories as to how this thing called rules of evidence, the operation of the evidence law, is used. All these words that exist on here has four main categories. Whenever any given supposition of evidence is introduced, either formally or informally. The first stage is they determine the applicability. The second stage is they determine the admissibility. The third stage is they determine the authenticity. The fourth stage, which is the last stage, is they determine whether any exceptions exist. And guess what? These exceptions we've been going over when it comes to hearsay rule, types of objections, so on and so forth. Anything dealing with the rules of evidence in the past and the future, we've been going over that. When we speak about self-authentication and the elements of an affidavit, that's what makes a self-authenticating evidence. Again, the first stage is applicability. Does this thing even apply to what is going on? Second stage is admissibility. If it applies, then can it be admissible? If it then is admissible, how authentic is it? If it's authentic, one way or another, whether by virtue of some form of certification, or whether by on its face itself, whether it's substantial evidence or prima facie. Is it self-authenticated? Good. Now, are there exceptions on the other party's end to see if any of this can be applied to this, quote, totality of circumstance? Let's deal with the first stage, which is applicability. The applicability is in Rule 101 and 1101. Tells you scope. Tells you the scope of what these rules apply to. These rules apply, in other words, the applicability to proceedings in the United States courts. These United States courts merely adopt foundational ancient principles. So don't worry, keep running away from quote what you think is theirs. If only you knew that this whole thing is modeled after you. But if you don't know you, how can you ever put what was meant for you to use? How can you make them shake in their boots? How can you functionally make your life better rather than being angry and upset? Stay upset. Applicability, scope. These rules apply to proceedings in United States courts. The specific courts and proceedings to which the rules apply, along with exceptions. They're telling you the fourth part automatically right off the bat with the first part. Fourth part being the exceptions. Within the first part, which is applicability, they're telling you about the last part. Are set out in Rule 1101. They tell you which jurisdictions it applies to. And then they made reference to the annexed aspect of it, which is Rule 1101. Let's go to Rule 1101. What does Rule 1101 of the Rules of Evidence say? Rule 1101 lets you know applicability of the rules. The courts and judges, these rules apply to proceedings before United States District Court, which all courts on a state level has been homogenized, as I always say, based on the incorporation doctrine. On the patron page, we go into details of incorporation doctrine on how to properly reserve your right beyond UCC 1-103 307 208. Again, a lot of bandwagoning. The United States District Courts, United States Bankruptcy and Magistrate Judges, United States Courts of Appeals, Courts of Federal Claims, and the adjoining islands. Goes on to the details of the exception. Summary of the exception tells you that these do not apply to grand jury proceeding. Now tell me, you and everyone else is saying you want to bring criminal charges against these people, right? If you don't know how to use, invoke, or even what a grand jury, if you don't know what a grand jury is compared to a regular jury, whether it's trial by jury or jury trial, whatever it is people want to call it, if one does not comprehend the foundational difference between a regular jury and a grand jury, you're not going to hold these people liable for anything. You will be considered an illegus, and one will stay upset. And these rules do not apply to grand jury proceedings. You want to know why? See, you have to read what a lot of people run away from to know where the solution is at. The grand jury proceeding, without going too deep into it, is what is mentioned within the Fifth Amendment of the United States and your respective state constitutions regarding how you can bring indictment of criminal charges against people by way of the people itself. They're letting you know these rules, no matter how much it gives you leeway or confine you based on your competence, the grand jury has a law that governs them when it comes to evidence outside of this. We'll say that, we'll leave it at that. Then goes on to tell you these don't apply to extradition or renditions, meaning if and when you have extradition warrants. The rules of evidence are exceptions. Did you know that? Whenever you're dealing with extradition warrants, rules of evidence are considered exceptions. Now, you can still invoke it, but if you don't read the language of what you're running away from, you would not know the loopholes used as to why and how you can invoke it despite the exceptions, which is an applicability and the authenticity. The exceptions also include issuing an arrest warrant, criminal summons, or search warrant, qualifying term being the issuance. Preliminary situation regarding criminal cases, sentencing, granting or revoking probation or supervised release, or consideration of release of people. Now listen to this part. Remember, we're only talking about applicability. We haven't gone into admissibility or the authenticity. Within the applicability, you're seeing the exceptions. But despite these exceptions, which most people will be facing if they're really facing some serious situation, it gives you a little quick jewel. The rules on privilege apply to all stages of case or proceeding. These rules do not apply to the following, which we've just read. And then right in a minute, it'll tell you, except for those of privilege. Now, this warrants you to know what rules of privilege are and the elements behind rules of privilege. Let's go to the second stage. The second stage is the determination of admissibility. See, just within the first stage alone, so much intricacies already exist. Someone is at least intending to downplay the significance of what is shown or what others show to them by virtue of what they've learned. The least they can do for you is to clarify why what they're downplaying is irrelevant and how they can assist you to make things relevant in your life and things that you could do to counter the possibility of what they're downplaying to not be significant. When they're in a circumstance, they tell you, well, what that man or woman is saying is insignificant. They don't know what they're talking about. The least they can do is show you this. And if they don't show you this after downplaying something, they've just lied to you, because the omission of truth is synonymous with falsehood. If someone downplays one thing to you, that means they're trying to sell you something else. So now it's up to you to question what they're trying to sell you and to see how useful it is, how you can apply it. Then you ask them whether the opposite of what they're downplaying has been used to their benefit somehow. Ask them. But nonetheless, if anyone is to downplay anything, this is the least they could show you at least. Second, as mentioned, is the admissibility. That is in Rule 401, 403, basically 401 all the way to 407, and then 701 to 705, which is the hearsay. 401 determining whether the evidence is relevant or not. Is it relevant? Is it not relevant? 401 tells you that. And then 403 tells you, well, even if it is relevant, can we still exclude it? Does it create prejudice? Does it create more confusion, waste of time, or other reasons? Which most of the time, what most people will find in PDFs or listen to creates confusion, is a waste of time. And this loophole called other reasons, they will bring something up because you don't comprehend some of the subtleties. Again, at least one can do is to show you how they do that against you. At least know how they function. Right? Right. 404. We went over 404 in the past. There's a lot more in this Rule 404 besides the whole double jeopardy situation. But we went over one of the attributes before. Basically what 404 all the way to 406 does, 404 being character evidence, 405 being methods of proven character, and 406 being habit, routine, and practice. Basically what these three sections do is they determine whether there are other reasons to exclude certain types of evidence. Remember, you can do this also. And they determine whether there are subsequent things attached to it, which is in 407. And then the good old 701 all the way to 705. This is still within the realm of admissibility, which is when it comes to witnesses, which they will do this so quick that it will go over many people's head. You don't have to be in a formal court trial for this to occur. IRS will send you letters doing this, because those people sending you letters, whether it's IRS or any other employee, they are deemed to be professionals at what they do. According to Rule 701 all the way to 705, they use these tools against you. opinion testimony by lay witness, testimony by expert witness, basis of expert's opinion, opinion on ultimate issue. And the underlying fact behind everything else. Now, if all that has been qualified and it somehow is admissible, guess what? They go, okay, all right, it's admissible, but is it an hearsay? We went over hearsay in the past. It's in 801, 802, 803. Exceptions to rules against hearsay. Now, if it passes this stage, they determine its authenticity, which is in Rule 901, 902, 903. Authenticating or identifying evidence. Just because you put something on pen and paper and you feel passionate about it is not enough for it to be applicable, admissible, self-authenticating, or qualify under the exceptions. See the reason why lawyers are very comfortable kicking people's ass? See the reason why these people are so comfortable doing whatever it is that they want to do to you? In the past, we've spoken about self-authenticating evidence and authenticating evidence. And the other little thing that they use is in Rule 1001 all the way to 1004, which is the means in which the evidence is introduced. Is it in writing? Is it a recording? Is it a photograph? Is it original? Is it a duplicate? They define it for you. Man, when you want to start bringing evidence in, you have to be in accordance with the definition of itself, written within the operation of law of evidence. Not some Black's Law Dictionary. See, use Black's Law Dictionary to study case laws. That's what they're there for. That's why they're called law dictionary, judge-made law dictionaries. That's what law dictionaries are for. Use those. But don't rely on this definition to come into certain world or certain realms or certain aspect. Then they show you when they require the original and the admissibility of the duplicates that you make, the admissibility of other evidence and content, and the copies of public records to prove content. If anything is not received in everything that you are hearing, at least learn these 4 basic categories of rules of evidence. And you will be doing yourself a huge favor to be able to discern trash that others tell you when they try to either downplay something or try to hype it up. Until next time, take care. As always, really, best of luck. Hey, beautiful people, I'm inviting you to come join my Patreon page. We speak about everything we don't speak of here on YouTube. On the Patreon page, we speak of establishing privacy in many different means, how to hold tortfeasors liable, the different types of discharge, and the steps to actually do it. Now I'll be showing my own proof of the success, the intricacies involved in why and how it works, and the things no one else would tell you because they've never discharged themselves. The intricacies of settlements, suing people, and many other basic things like other tools that you can use privately, things of spiritual nature, because this goes beyond what you observe with your 5 senses. And if you just want to limit your remedy to just what you observe with your 5 senses, think again, because the other side is not playing in that realm. It's not an even playing field. Other things like study tools are shown things regarding trust and asset protection and how to lay your trust properly the way people seek it, and the advantage of how to do it, banking, the functionality of how they function, and the validity of it that a lot of people misuse or are misled by, where they think, oh, these other guys are bad, so now I have to just go into argument mode. No, you don't always have to argue. The law is perfected for your benefit if you're competent about it. Many things regarding child support, different examples of settlement checks, and the videos on it, the different aspect of how you can broaden your mind internationally beyond the little chicken scraps that people are picking up when it comes to passport and things of that nature, how banking work, how property protection work, the details of copyright, tort, privacy, different types of trust, the intricacies, and exactly why and how they are done, the intricacies that people from other part of the world know about trust that you don't. Just because you read something on social media and whatnot doesn't mean you really got it. The intricacies of how to use certain jurisdiction and the stuff everyone speaks of. More in child support, more in trust, more in court, more in spiritual nature of things, etc., etc. The fact that tax avoidance is different from tax evasion. The importance of things in commerce and how to actually function in commerce. How to actually really do things as a natural person is beyond speculation. But let me give you this caveat. If you're looking for a cookie cutter or some quick fast food way, this is not it for you. Either here on YouTube or on Patreon. But if you're serious about your education and the function and application of it, rather than the mere accumulation of information, then come on over on Patreon. There are things we speak about over there that are universally and exponentially beneficial compared to that of the ones we speak of on YouTube. And more importantly, the practicality and the actual use of it. Take care. Best of luck.